watching, you need to know very, very carefully here. John Quinn, the founder and chairman of Quinn, Emanuel, Urquhart and Sullivan, is with us. So John, come out here and
thank you.
Inspire us. Thank you so much. Please don't leave. And the people at the back, come up to the front. Please come join us in the front here. We've just got a few more people to go through. You won't want to miss the last messages of the evening. John, I'm handing to you.
Thank you. When we think about AI and IP, there's so many issues that have not been resolved in the law now. The courts are dealing with novel issues that they haven't struggled with. Let's begin with the very idea of, with all these billions of dollars of investments that are going into AI, how are they protected from an IP standpoint? You might think, well, they'll just be patented, but that's not necessarily true. You cannot patent an algorithm. You cannot patent a mathematical technique. You cannot patent a data set or some way of manipulating data. That is not patentable. I'm not talking about the hardware, the NVIDIA chips. Obviously, you can patent that. So how do you protect all these investments that are going into AI? I think the answer to this is going to be an increased reliance on trade secrets, a different way of protecting information. A patent, you file something with the patent office, you get something back with a ribbon, it lasts for 20 years, but only 20 years. You have to disclose it to the world. With trade secrets, as long as you keep your know-how, what you're doing, your special sauce, confidential, and as long as it has value by virtue of the fact that it's not generally known, you can protect it indefinitely. You have to police that. You have to make sure that you keep it confidential and it stays trade secret. So those NDA agreements, all those things really do matter. But how about inventions by AI? So much of the invention that's being done now is being done by AI. You look at the Google Mind, and I saw something where they had discovered something like 2 million new crystals, which have all different applications. This was created by AI. AI is discovering materials, processes, and the like. But guess what? The patent office takes a position, as does every country in the world except South Africa, as I understand it, that inventions made by AI are not patentable. AI cannot be an inventor. So what does this mean? If so many things are being created by AI and it can't be patented, maybe patents become irrelevant. I mean, so we don't know this interaction between intellectual property law and patent law, where that's going to end up. Another issue relating to data and data sets is scraping. You know, so much of the AI is powered by large volumes of data which bots take down from the web. Now, the web hosters aren't necessarily happy about that. There's been cases brought by LinkedIn and brought by Meta trying to stop people from scraping. So far, the scrapers have been winning those cases. But I think this is going to be a battle back and forth on terms of the terms of service and the like. But the web hosts are not the only ones who have an issue with scraping. People have an issue. Their information is being taken and scraped. Now you might say, well, you put it out there in public, you put it on the website, how could you possibly have any privacy interest? But what we're seeing, and it's getting some traction in the courts, is, yes, I put it out there, I put it in the public domain, but I never anticipated that somebody would scrape it and make this other use of it, that they would monetize it and they would get some benefit from it. I never consented to that. So we're seeing those types of claims, the issues about privacy. So scraping continues to be a very, very hot issue, and we're going to learn more about how the law develops there. You've all seen the cases relating to copyright and generative AI, the New York Times versus OpenAI, Sarah Silverman, visual artists, musical artists, who are objecting that basically they have two kinds of objections. One, you know, the input that you're training these data sets using proprietary copyrighted material, and that's an infringement, or that the output is an infringement. What's coming out the other end? The defense is, you know, on the input side is really just that, look, this all happens in the, you know, under the hood. Nobody sees this, and it's what's termed under copyright law. The argument is that's a fair use. In other words, what's a fair use? It's a very technical doctrine, but the idea is basically that, you know, if you're not inhibiting creativity, you know, if you're not eliminating the market for copyrighted works, it's okay. It's a fair use of copyrighted material. We don't really have any decisions on this yet. You've read about them, but the courts have got to address this issue. On the output side, you don't really see OpenAI or other generative AI companies, the output, which is substantially similar to the copyrighted work. And that's the test for infringement. Once in a while it happens, you'll see something that's very much like a copyrighted literary work or visual image. And as I understand, the generative AI companies have a difficult time explaining how that happens sometimes. But these are all issues that are going to have to be worked out. The copyright issue, the scraping issues. Another issue relates to that's open-ended is products liability. In 2018, a Uber car hit a person who was jaywalking. Now, the driver wasn't paying attention. The driver, was an autonomous car. The driver was on their phone. Who's at fault under traditional products liability laws? Is it the manufacturer of the car? Is it the engineer? Is it the AI itself? Well, the state of Arizona charged that driver with negligent homicide, so they made at least a judgment that far, but it really remains to be seen. These products liability issues and how they're going to play out, these all very much remain to be decided. A lot of these are going to end up being decided, I think, in regulation. We're probably not going to see, my guess, national legislation in this country coming out of Washington. How many of you think there is a national law on privacy in the United States of America? There isn't one. Couldn't get it together, can't get it out of the committee. How many of you think there's a national law regulating social media? For all the time we've been wringing our hands about the potential problems with social media. So it's happening in the states. Something like half the states now have some type of regulation of AI, mostly directed towards use of data sets and concerns that data sets might be biased in terms of making employment decisions, or who gets a loan, or who gets an apartment, and things like that. Deep fakes also have gotten attention in state houses in states across the United States. Law enforcement and use of AI, facial recognition, those are all of interest. But I don't think we're going to see national legislation. But what we are going to have is a comprehensive AI law coming out of the EU. The EU AI Act, which they've been working on for about 3 years, is on the verge of being officially adopted. And I think, like the GDPR, the way the GDPR set a global standard for privacy, I think that European AI Act is going to set a global standard for AI. This has been termed by some people a Brussels effect. Brussels gets out in front. No major company is going to have a different policy in Europe than they're going to have in North America, or they're going to have in Asia or elsewhere. So they end up, by default, complying with what comes out of Brussels. So I think that's the regulation we're going to see. If I were giving this talk a year from now, I'd have some answers to some of these questions. The courts are going to make decisions. Things are changing so fast. The legal system, in the best of times, is not fast. It's struggling to keep up and deal with these new concepts under old legal labels. Thank you.